whereas it seems that this present government wants to bulldoze a constitutional amendment. The proposal that this government is backing is not even consistent with what was provided in this case in point on DawnNews English. Today we're going to talk about the proposed constitutional package. We'll talk about the contents of the package, how it destroys our existing judicial structure and creates an entirely new superstructure, and how many of the provisions of the package are inconsistent with judicial independence. The Law Minister, Mr. Azam Nazir Tarar, has partly defended the package, and this is a package that the government is actively pushing for. Firstly, let's talk about the power and the process to amend the Constitution. The relevant articles are Article 238 and 239. A bill to amend the Constitution may originate in either House of Parliament, the National Assembly, or the Senate, but it must be passed by 2/3 majority of the membership of both houses. However, the power of Parliament to amend the Constitution in our dispensation is not absolute. In the past, the courts have held that the salient features of our Constitution include a parliamentary form of government, an independent judiciary, democracy, fundamental rights. To the extent that any constitutional amendment violates any of these salient features, the courts have the power to strike it down. And this is based on the principle that in our constitutional dispensation, it is not Parliament that is supreme, it is the Constitution that is supreme. For example, Parliament does not have the power to amend the Constitution in a manner which undermines or attacks an independent judiciary. And in our Constitution, at the very outset, it states that we, the people, give to ourselves this Constitution, and the Constitution is the people's document, which is the supreme document. As far as procedure is concerned, in the current circumstances, the Khyber Pakhtunkhwa Senate elections are yet to take place and the House is not complete. It would not be appropriate for any constitutional amendment bill to be passed when one province does not have adequate representation in the Senate. The second aspect of procedure is that in a parliamentary democracy, consultation, inclusion, and participation of relevant stakeholders is crucial before legislation is passed, and this threshold is even higher when it comes to a constitutional amendment, whereas it seems that this present government wants to bulldoze a constitutional amendment. Now let's talk about the contents of the amendments. One of the proposals includes creating a federal constitutional court. The Supreme Court will be bound by decisions of the Federal Constitutional Court. The Federal Constitutional Court will sit over and above the Supreme Court. Such constitutional courts exist mainly in civil law jurisdictions. Pakistan is a common law jurisdiction. We have a diffused model where the High Courts and the Supreme Court are regarded as constitutional courts. Another proposal includes the fact that the first Chief Justice of the Federal Constitutional Court will be appointed by the President on the Prime Minister's advice. And this is completely inconsistent with principles of judicial independence. For the Prime Minister to effectively handpick the first Chief Justice, the government will be a party to cases which are being heard in the Federal Constitutional Court, and it would not be proper for the government to effectively handpick the first head of the Constitutional Court. Representatives of the government keep referring to the Charter of Democracy, but even the Charter of Democracy provided that the judges to the Constitutional Court will be appointed by the Judicial Commission. The proposal that this government is backing is not even consistent with what was provided in the Charter of Democracy. The other aspect in the proposals is the role of the Supreme Court and how the proposals completely diminish and effectively abolish the Supreme Court. The Supreme Court will no longer hear constitutional cases. The Supreme Court can no longer hear appeals from writs which come from the High Courts. And this begs the question that after the proposed amendments, what role will the Supreme Court really play and what role will Supreme Court judges really have? And the proposals really effectively do annul the Supreme Court. Another proposal includes the fact that the judges of the High Courts can now be transferred without their consent. Previously, the consent of a High Court judge was required before they could be transferred, and now a judge can be transferred upon the recommendation of the Judicial Commission, and this provision may be used against judges that are dispensing justice without fear and without favor, and this provision may be used to punish independent judges. We saw the 6 Islamabad High Court judges recently write a letter about interference by the intelligence agencies in the judiciary, and now this provision has been included in the proposed amendments, which allows High Court judges to be transferred without their consent. One of the proposals also states that the High Court shall not pass an order against any person that is performing a function under laws relating to national security. This provision will have drastic consequences in cases of enforced disappearances. In cases of enforced disappearances, the allegation is against the state, and this gives the state an opportunity to say that we are doing what we're doing under the garb of national security. And we recently saw the Islamabad High Court taking action in cases of enforced disappearances, not just in relation to the recovery of the disappeared person, but also accountability of those who are found to be involved in enforced disappearances. And as I said, the allegation is against the state in cases of enforced disappearances or those acting on the authorization of the state. And this will undermine the ability of the high courts to hear cases and to dispense justice in cases of enforced disappearances. Another proposal states that laws relating to the armed forces and certain laws relating to the armed forces and the appointment, reappointment, retirement, removal, and extension of the service chiefs, including the naval chief, the chief of army staff, cannot be altered except by way of a constitutional amendment. This proposal gives constitutional cover to ordinary legislation pertaining to the armed forces, and it is not clear why these laws need constitutional cover, and it undermines the ability of a civilian government to make changes to certain laws relating to the armed forces unless they have a 2/3 majority. So in summary, the proposals give constitutional cover to certain laws which relate to the armed forces, but they undermine and destroy the independent functioning of our judicial system.